Hello, welcome back from wherever you are in the world. A warm welcome to Chapter 8's lecture. And why am I emphasizing where you are in the world? Because we are today going to talk about international commercial contracts. And you hear some enthusiasm in my voice. And the reason is that from a legal perspective, and I also think from a business perspective, international contracts are extremely interesting. Why? Because it's extremely complicated, and from a business perspective, because it usually involves large amounts of money, and it involves opportunities for companies to expand into new markets by finding customers abroad. But before we start with the actual topic, a bit of a recap. What you see here is a formula, and this formula is a so-called conceptual contracting formula. And the formula applies, the top one, to civil law and the one below to common law. We can very simply say that Chapter 6 we introduced the offer and acceptance concept, and when they are both present, a contract originates. We looked into common law and found some slight differences resulting from the fact that under common law, a contract is a commercial instrument. The emphasis is on the commercial application of contracts. Now that resulted in some slight differences with respect to the requirements for contracting. Common law takes the stance that offer plus acceptance does not suffice. An intention of the parties to be bound is required, and the commercial nature is reflected, and that's the CO, in the consideration requirements. So a few more, to be exact, 2 requirements for contracting under common law. In Chapter 4, we looked into the transfer of property. There was a link, I hope you remember, between transfer of property and contracts. Because if we look at the civil law property transfer formula, the formula is that somebody needs to have a right, usually that is the owner, and the owner has the right of disposal, so he can sell a movable. When that is with a contract which is valid, and a valid contract results from a valid offer and a valid acceptance, then the right of disposal plus the contract plus a delivery result in the transfer of a movable property. If we go to the common law property transfer formula, we see some differences. What basically remains the same is that you cannot dispose of something you are not owner of. So we also need as a start this right of disposal. Then we also need a contract, but as we saw, the requirements for a valid contract slightly differ. But then comes the real difference. The transfer moment is either as intended by the parties, so the parties can decide freely on the moment at which ownership transfers. That's the starting point. If they don't, then the moment at which the ownership of a movable transfers is the moment at which the contract is concluded. So we must answer a question on at which moment does the ownership of a movable transfer under common law. First look into whether the parties decided upon the moment, expressed an intention for the moment of transfer, and when that is not the case, we must resort to the moment the contract was concluded. Now, I already introduced here Incoterms, that comes later in the lecture, but you can consider an Incoterm which in itself does not regulate transfer of ownership under common law as an intention of the parties for the moment at which ownership transfers. Look in the book on page 203, study table 4.3 in the book, and you have, I hope, an understanding of how it works under common law. Now, in chapter 7, we looked into legal forms, the entities which can exist independently and can participate in economic activities, or simply said, can participate in business. Now, if we take the simple formula for contracting, consisting of offer and acceptance, then we can draw from that the conclusion that a legal form can make an offer and the legal form can accept, and if offer and acceptance are done, a contract originates. The complexity which we introduce here and which results from chapter 7 is that a legal form, when it is a limited liability company, assigns authority to represent it to generally a board. So the board of a legal form has the authority to represent, which means that the board makes an offer and the board of that other company accepts the offer. Then a contract originates. We know that contracts are binding, and in this system, the two parties which are bound are the two legal forms. They are represented by the board makes an offer, the board accepts, and by doing so, the boards bind the legal form. That is the system when we place the offer and acceptance principle in the context of chapter 7 of legal form. Now let's get back to the learning objectives of this course and see how they relate to international contracting. Basically, if you view in your mind the EMEA map and your company is considering to internationalize by exporting or selling otherwise in other countries, you run into the topic of today, international contracts, because international contracting is about two parties which each are in a different jurisdiction and resulting from the fact that law is national under a different legal regime. That means that you will be confronted with things you don't know, with lawyers who work and think differently, with business partners who work and think differently, and that automatically leads to, although it's maybe a bit exaggerated, a clash of cultures, of your own national culture, of your business culture, of the legal culture. So this pluralism, we focus on the legal pluralism, this legal pluralism may result in ethnocentrism, which in general is not beneficial for doing business. Where business people speak about international business or exporting, lawyers speak about international law, and more specifically, because we're dealing with contracting, about international private law. Yet, here we also have a difference between civil law, Islamic law, and common law, in the sense that international private law is a civil law, Islamic law term, while common law refers to the same as conflict of laws. Both deal with an important question in international contracting, and that question is which law applies to the contract. As said, international private law deals with the question which law applies to the contract. But we should first realize ourselves that we can have different types of contracts and as a result different types of international contracts. We focus on the commercial contracts of most relevance to business, that are sales and services contracts. Now, these sales and services contracts can be concluded by two companies, by a company with consumers and by consumers with another consumer. So that leads to a bit of a complicated puzzle. It means that in international business, we may be involved in international B2B sales contracts, international B2B services contract, international B2C contracts, and international B2C services contract. Those type of contracts may lead to different legal conclusions. Too early to conclude on that now, but just to make you aware of the fact that You may be involved when running an international business in different types of international contracts. Now, let's first look at an international sale of goods contract, a contract for movables. Although we mentioned the word services in the overview, the focus will be on sale of goods. I try to explain to you the complexity of what is involved. We start here with Party X, and Party X is in a jurisdiction with a national legal system. Party I is in a different jurisdiction, and they enter into, because they are in different jurisdictions, an international contract for the sale of goods. A question on the sideline is, do they need finance? One, the seller, for producing, the other, the buyer, for financing the purchase of the goods. That may involve contracts with a bank. Another issue in international contracting is payment. You can imagine that more risks are involved, and that especially, of course, the seller does not want to run the risk, or at least wants to mitigate the risk of non-payment. Because in an international contract, money has to go from the buyer to the seller. Later on in the lecture, we will see that the international business world and banks have made a tool which facilitates payments in international contracts, a tool which reduces the risk of non-payment for the seller. It involves two banks, the banks of the buyer and the banks of the seller, and the contract which mitigates the risk is a so-called letter of credit. Details will follow. Then we have another issue to look into, and that is, because we are talking about goods now, we must realize that generally these goods require transportation from one country into another. That will generally involve another party in the sale, and that other party is a carrier, a transportation company. That transportation company will have a contract with the party who transports, and that can be the seller and that can be the buyer. The International Chamber of Commerce has created terms to facilitate international sale of goods transactions, and these terms have consequences. These terms have consequences, for example, for when the risk transfers and who contracts for transportation. Now, these obligations may affect the price, and the price will affect the offer which the seller at a certain point makes to the buyer. So this is an overview, a starting overview to make you aware of the many dimensions of an international sale of goods contract. Risk management is an important part of business, and law makes a contribution to risk management by legal tools, contracts being one of them. But first, we should identify what, in the context of international contracting, are the typical legal risks. And we also pay some attention to typical business risks. The legal risks are, and details will follow, the law that applies to the contract. Is your contract under Dutch law, English law, Russian law, or whatever? All is possible. The moment that the risk transfers, when we talk about the sale of goods, from seller to buyer, that's an important moment, because with the transfer of risk, the liability for damages rests on the owner of the goods, or it may be regulated differently, but that is what we will find out when we look at the Incoterms. Clauses can contain all kinds of Contracts can contain all kinds of clauses, for example, liability limitations. If that is the case and you have accepted it, it can result in a risk. The question in international contracting is also, if there is a dispute, to which court in which country must or should we go? And if, for example, a Dutch court decides that a Greek company has to pay you a compensation for damages, can you then go to Greece, seize property of the Greek company in Greece and have it sold in Greece in order to generate proceeds to settle the debt? Those are questions which pop up in the context of international contracting. What pops up as business risk are fluctuations in currency, political risk, Brexit, how will it be ending? Will the parties come to an agreement, and what will the contents be? War, revolutions also create risks for international business. The credit risk, will there be a payment in time? As already discussed under Chapter 6, third party risk, you're dealing with foreign counterparts. How can you make sure that they do not behave in a way which could have a negative effect on your reputation? And you can imagine that crossing borders, entering countries, comes with all kinds of documents, for example, customs documents, and you, as a company who is selling abroad or exporting, must make sure that the documents are properly managed. So there are quite some risks involved. There's a price to be paid for the amounts of money which you can make when you sell your products. We talked about risks and we mentioned the word tools. Law makes tools available to manage risks. If we look at law from that perspective and we take into account the risks we just mentioned, we can identify the tools by identifying the sources where we find rules for the typical risk we just introduced. And we have international tools and EU tools. Now, when we are talking about the risk of which law applies to the contract, we have the EU1 Rome regulation. When we talk about international sale of goods, we have to realize that there is a convention on the international sale of goods. When we ask ourselves the question, to which court should we go or can we go, we have an EU regulation, which we refer to as Brussels I recast, which will tell us how it works in the European Union with respect to that question of the competence of which court. When within the European Union we are interested in the question, can a ruling of a court in one EU member state be enforced in another member state, we find the answer also in the Brussels I recast regulation. And finally, we have been pinpointing from time to time alternative dispute resolution mechanisms. You will probably now be aware of the fact that companies prefer arbitration over litigation, and there is a so-called New York Convention, which provides rules for the foreign recognition and enforcement of arbitral awards. In other words, is an arbitral award made in France also valid in the Netherlands or in Russia? Those questions are to be answered with the tools presented here, the sources of rules for finding an answer to questions related to the typical legal risks of international. The first source we discuss is the Convention on Contracts for the International Sale of Goods. The green countries are signatories, so they participate in the convention, they've signed for it, and by signing it, they indicate that they will follow the rules of the CISG. These are all the countries. So whenever you encounter, in a case or in reality, an international sale of goods contract, you want to know whether this convention applies. The convention gives its own rules. The convention tells us when it is applicable. And that applicability is what we call the scope of the convention. Now, do pay attention, because understanding this will help you fantastically in answering questions on this topic. When we have a contract for the sale of goods, we have a buyer and we have a seller. Article 1 states that when buyer and seller are both in a CISG country, think back of the previous slide, the CISG applies. So the A situation is not complicated. The B situation of Article 1 is not immediately easy to understand, because it requires some more knowledge. In international private law, we have referral rules, and a referral rule, as the word says, refers us to the law of a country. The CIG makes use of this principle by saying the CIG also applies when the rules of private international law lead to the application of the law of a contracting state. So when by a referral rule we end up in the Netherlands, which is a CIG member state, it means that the CIG applies, and applies prior to the national Dutch law. When we discuss the Rome I regulation, this becomes more clear to you. When we go to Article 6, we see the party autonomy principle reflected, in the sense that the parties can decide not to be bound, not to have the contract governed by CIG rules, by simply opting out, by excluding it. The CIG in Article 11 also applies the simple principle of offer and acceptance leading to a contract, and Article 25 introduces a new concept, and the concept is not breach. We know that non-performance is in principle a breach of contract, but non-performance under the CIG is not immediately a breach of contract. That non-performance must be fundamental. That is important in the context of dissolving a contract, setting a contract aside. The CIG uses the term avoidance, and for avoidance, the breach must be fundamental. Now we make a step, and we will come back to the CIG. Now we make a step towards an EU regulation. Because it is a regulation, the rules are identically applicable in all member states. What is the principle of this Rome I regulation? We are talking about the applicable law risk. The principle is party autonomy. So within the EU, parties can freely decide on which law applies to the contract, completely or to parts of it. So a Dutch company and an English company can agree on English law to be applicable. A Dutch company and a French company can agree on English law to be applicable. A Spanish and a Greek company can decide on Italian law to be applicable. You have the freedom to make a choice, and here you find an example of that choice, and the clause in which you find such a choice we refer to as a proper law clause. What is the risk? The risk is that if there is a future dispute, the court will look into the contract, the court will see and decide on which law is applicable, and the dispute will be decided under those rules. So the dispute might be decided under English law, Dutch law, Italian law. That is all possible. Now, when discussing the CIG, we said a referral rule may lead you to the law of a specific country. Rome I contains referral rules in case the party autonomy is not used, in case the parties did not make a choice. In case the parties did not make a choice, the following referral rules apply, and we will, of course, as always, focus on sale of goods and provision of services. If there is a sales of goods contract and no choice is made, the Rome I regulation refers us to the national law of the seller. If that seller is a CISG member, it means that the CISG applies. If the referral rule leads us to a country which is not a member, like, of course, the UK, it means that the national law of that country is immediately applicable to the contract. With the provision of services, the system is comparable. The law of the country of the service provider applies to a contract when the parties have not made a choice. That is what we will focus on, because our focus is on sales and services contracts. For other types of contracts, you also find referral rules in the Rome I regulation. Now I want to warn you for something, and that warning is because experience learned me that many a student at an exam mixes things up. And that's why I give you here this extra warning. Applicable law and competent court are two different questions. One does not affect the other. They should be considered as separate questions with separate rules for answers to questions on these issues. You better be warned not to mix it up in an exam. Now, what is the system of this Brussels I recast? We start again with the same principle as for the Rome I regulation, party autonomy. You, as parties to a contract, two companies, have the complete freedom to agree on the court you will go to in case of a future dispute. You can put that in the contract, and the clause which indicates your choice for a competent court in the contract is referred to as a choice of forum clause. We had choice of law clause or proper law clause. Now we have the choice of forum clause. Here you have an example from a typical clause from a business-to-business contract. Disputes that are not possible to be resolved amicably. So let's please try to solve any dispute among us and avoid having to go to court. But if we cannot solve it amicably, we're going to submit it to the exclusive jurisdiction of the competent court in Amsterdam, the Netherlands. So this is the use of the party autonomy by agreeing on the court which is competent for a dispute. If there is no choice, then the situation is that when you want to sue somebody, you have to do that in his country. So when a Dutch and a German company have not included a choice of forum clause, then when the German company wants to sue the Dutch company, the German company has to go to a court in the Netherlands. If the Dutch company wants to sue the German company, it has to go to a court in Germany. That's the system of the Brussels I recast with respect to competence. As so often, law has its exceptions. We just said that the basic rule of Brussels I is to sue somebody in the country in which he lives. This is expressed as domiciled in a member state. But Article 7 gives an exception. You may also sue a person in another member state than he lives in. And within the focus we have on sales and services contracts, Article 7 provides two exceptions. In the case of the sale of goods, you can also sue, litigate in the member state where under the contract the goods were delivered or should have been delivered. So if a Spanish company expects its goods to be delivered in Spain by a Dutch transportation company, it could sue the transportation company, which is Dutch, in Spain because it was expecting the goods to be delivered in Spain. When we talk about the provision of services, we saw that the starting point in the Rome I regulation was that the law of the country of the services provider applies. When we look at it, at services contract in the context of competent court, this article states that there's another place to sue the service provider, and that is where under the contract the services were provided or should have been provided. So when, for example, a Dutch and a Belgian company agree on the Dutch company performing market research in Belgium, the Belgian company need not go to court in the Netherlands if it sues the Dutch company, but could rely on this exception in Article 7 and state that the services were to be provided, done in Belgium, and therefore it can sue in Belgium. We regularly discuss the choice which two companies have in a B2B sales or services contract to decide, to agree upon, not to go to court, to avoid litigation, and to do so by agreeing on arbitration. Arbitration is extensively used in international business to business for reasons that going to court has certain disadvantages, but also because there is a good international system for recognition and enforcement of arbitral awards. That system is the result of the New York Convention 1958. All the purple, blue countries you see on the globe. All of a sudden my phone starts speaking. All the countries you see in blue on the globe are members of this New York Convention. You will find in the slides some statements from that convention, and what it comes down to is the following. If an arbitral award is made in any of the participating countries, that arbitral award is recognized in all countries of the New York Convention, and as a result of the convention, it is enforceable in those countries. So a Dutch arbitral award is recognized in Russia. Russia is also a member, and the arbitral award is enforceable in Russia. That in practice there may be some little problems resulting from the state of the judicial system. We leave that for the moment. It's about the principle, and the principle is that thanks to this New York Convention, companies in international business can to a large extent rely on the arbitral awards which are made on disputes which may result from a contract. A change of topic. Here you see Incoterms, you see 2020, that's the year they became effective, and you see that they are made by the International Chamber of Commerce. The ICC is a private international business organization which supports international business with all kinds of tools, ranging from templates for contracts to arbitration facilities and what we look into now, the Incoterms. The Incoterms are trade terms. These trade terms have a meaning, and the meaning is defined in a booklet published by the ICC. The parties can resort to the terms and to what is in the booklet and include a term in the contract. It is party autonomy which allows parties to do so, and because it is in a contract, it is binding. So in a court you can invoke the Incoterms, and the Incoterms define parts of the relationship between a seller and the buyer of goods, usually in international sale of goods transactions. In order to understand the Incoterms, it is advisable that you can visualize the path, the road, a product has to go from seller to buyer when we are talking about an international sale of goods. You should realize that the seller is in a country and that the buyer is in another country. If the country requires so, export documents will have to be made. Who does that? The seller or the buyer? Then the goods must be loaded and transported. Seller or buyer has to choose a means of transporting, and loading and unloading involve cost. Who bear those costs? Then the actual transportation must take place. That involves risk and cost, and at a certain point in time the goods arrive in the country of destination, where they have to be unloaded either by the seller or the buyer, and often require another transportation within the country of destination in order to arrive at the premises of the buyer. All these steps involve risk, and all these steps involve cost, and that is what the Incoterms clarify by including an Incoterm, by making a choice out of the available 11 Incoterms. The parties define parts of their relationship, and how it is defined is found in the booklet of the ICC, which details all of the Incoterms. So the question now is, what is regulated by the Incoterms? And let's try to be perfectly clear about it. The Incoterms define obligations of the parties with respect to paperwork, with respect to loading, unloading, with respect to who takes care of the transport, who has to pay import or export duties. All these questions result, an answer to these questions, result from a choice for an Incoterm. And then, and that's the most important part of it, we are talking here about a seller and a buyer in different countries, with goods having to go a long road from one country to another, and on that road risks are present. Goods may be damaged, goods might be lost, the truck may drive off the road, the ship may sink, all kinds of problems can occur, and the question then is, who has to bear the consequences of that risk? Is it the seller or is it the buyer? The answer to such questions results from the choice of an Incoterm, because each Incoterm defines the moment of risk transfer by indicating what the delivery moment is. And then finally, closely related to obligations is cost. Resulting from the obligations, costs are to be made, so the Incoterms also indicate which costs are to be borne by either the seller or the buyer, or in certain cases, the transportation company. But there are some issues which, as a starting point, the Incoterms have no relevance for. The main one being transfer of ownership. Bear in mind that the Incoterms regulate the moment risk transfers, but do not regulate the moment property transfers, because the moment that property transfers is left to the applicable national legal system. However, under common law, or maybe I should say more precisely under English law, the viewpoint can be that the choice of an Incoterm indicates the party's intention on the moment of risk transfer. And we know that under English law, it is not the delivery which finalizes the transfer of ownership, but the starting point is the parties decide by themselves. So under English law, we can encounter the situation that indeed Incoterm and transfer of ownership are very closely related, which is not the case under civil law systems. The Incoterms do not involve rules on remedies or force majeure. That is left to the applicable national law. They do not regulate anything for intellectual property rights, and they do not, to emphasize what we just discussed, they do not have any relevance for the applicable law or for the competent court. So the focus is on risks, the focus is on the moment the risk transfers, and from that and the other obligations, it becomes clear which of the parties has to bear which cost. Now here they are, the Incoterms. And first of all, we make a distinction between two types of Incoterms. We have on the left-hand side the Incoterms we can use for any mode of transport and which we can use for combinations of transport modalities, and that is referred to as multimodal transport. On the right-hand side, we see a ship, and those Incoterms are only to be used for transports over water, inland or sea, so transports involving port to port. We'll run through them superficially and refer you to the text for a detailed explanation. First of all, we have a very simple one, and that is ex works. Ex works comes down to a seller, and the seller has goods, and the seller notifies the buyer that the goods are available. Usually that is at the premises of the seller. That means that all the rest, all the transport, all the documents are for the buyer to organize. The seller makes available, and at the moment he makes available, the risk transfers to the buyer. We have closely related to ex works free carrier, and free carrier differs from ex works in the sense that it involves loading. So the seller will not only put the goods at the disposal of the buyer, but will also load the goods into the means of transport, which is chosen by and paid for by the buyer. Then here we have two sea terms, and when we look and see an inland waterway, we also have two sea terms. The first sea term is called carriage paid to, and is slightly complicated in the sense that the sea terms involve two places. The first place is the place of loading, and the second place is the place of destination. Under each sea term, the seller transports to a destination, but the risk transfers earlier. The risk transfers at the moment of loading into the transport means. That is the case for all four sea terms mentioned here, so also for the sea and inland waterway transport, CFR and CIF. But you should be specifically aware of the fact that the risk transfers at the moment of loading into the transport modality. That is relevant because we see here an I and we see here an I. The I refers to insurance. Because the buyer has the risk from the moment of loading, so during the whole transport to the destination, buyer and seller may agree that, note my words, the seller insures the risk of the buyer. So the seller pays for and contracts with an insurance company that in case anything happens during the transport, and that leads to damage or loss for the buyer, because the buyer has the risk, that the buyer can rely on an insurance policy which was made for him and paid for him by the seller. Sounds complicated, but have a look at it in the text and realize that any C term is risky in terms of understanding because it involves two relevant moments, loading and arrival at the destination. When we talk about arriving at a destination and the parties want the seller to take care of that completely, they can better agree on a delivered at place Incoterm. If a Dutch company agrees on DAP with a Russian company in Moscow, it means that the Dutch seller will take care of the transport to Moscow, and once it is there, the risk transfers to the buyer. As the words of DAP say, delivered at place. A fairly new term in the 2020 Incoterms is the DPU term, delivered at place unloaded. If buyer and seller want to agree on the seller transporting and also unloading, they should agree on DPU. Finally, and that is the term which provides maximum service of a seller to a buyer, we have the DDP or delivered duty paid Incoterm. Suppose a Dutch company gets an order from an Indonesian company in Jakarta, and maybe the Indonesian company is not very experienced in importing, and the Dutch company is, so the Dutch company could offer, as another selling point, maybe even unique selling point, to deliver the goods completely to the premises of the Indonesian company in Jakarta. You can understand this involves some knowledge of exporting, documents, import tariffs, etc. But if you can offer it. So with DDP, you take care of the complete transport to the premises of the buyer. But of course, you also have all risk during the transport, and you have to take care of all documents during the transport. You simply take care of anything and you bear all risks until the moment the goods have actually arrived at the premises of the buyer. Now, CFR and CIF are comparable to CPT and CIP, which leaves us with two Incoterms to discuss briefly. Free alongside ship. Suppose a Dutch company agrees on free alongside ship Rotterdam with an Indonesian company, then the Indonesian company, who's the buyer, contracts a ship, notifies the seller on where the ship is, and because they have agreed free alongside ship, the seller will bring the goods to the quay in the port of Rotterdam. Literally, as the Incoterm says, free alongside ship. The seller can offer a bit more service. He can offer free on board, which means that he not just puts the goods on the quay, but also takes care of and bears the cost of loading the goods onto the ship. And that is the last term of this slide we discuss, the free on board term. Now, thanks to the internet, You can yourself find extensive information on the Incoterms, and some sites are even completely devoted to it. In this context, I would like to recommend to you the site incotermsexplained.com. Play around a bit, see what they have to offer to you, and by playing around, you can learn in more detail what the Incoterms are. And mark my words, they are extremely important in international business, although they are not law, but private rules. But as a result of the party autonomy principle, you can include them in a contract and in that way make them binding. Let's go back again, as often is very useful, to the fundamentals. And in the fundamentals, the global principles of contract law, we find party autonomy. Now, this freedom to include in a contract what you want has in practice led to all kinds of contract clauses with which parties to a contract can change, minimize their risk, and can provide clarity on issues. On the slide and in the chapter, you'll find some examples. Basically, the list is endless because, of course, party autonomy allows parties incredible freedom. But what we find in especially international business-to-business contracts is, for example, an exclusion of liability. We call that an exemption clause. One party may indemnify, if that happens in the future, the other party for certain costs. An example of that is, for example, for attorney fees. A warranty is a statement in a contract which states, which warrants, which promise that a product or anything else which is the object of the contract has certain qualities, certain features. Time is of the essence is an emphasis on a deadline. By this clause, it should become perfectly clear that the deadline should not be missed. If the deadline is missed, the time of essence clause means that missing the deadline is immediately a breach of contract. Parties can use a no waiver agreement. For example, you have in the contract that when the delivery is late, you are entitled to €1,000 compensation. Now the first delivery is 1 day late and you say to the other party, okay, 1 day late is not so serious, I will not demand the €1,000 from you. If there is a no waiver clause in the contract, that means that if the next time the other party is too late, you want the €1,000, that the party which is too late can no longer say, the first time I was too late, you did not demand the 1,000, so I can expect you not to do it anymore in the future. With a no waiver clause, you prevent that from happening. We know specifically from Dutch law that by delivery, ownership transfers. If you include in a contract a so-called reservation of ownership or reservation of title, you include in the contract a provision that states that ownership will only transfer after payment and not automatically by delivery. Penalty and interest clauses may be included. Now, you know that under Islamic law, interest clauses are void and cannot be enforced. Under civil and common law, they are used. However, if it is too exaggerated, the penalty or the interest, then under Islamic law, it will not be valid because interest is not a valid clause. But even under common law and civil law, it could be invalid if it is so exaggerated that under common law it turns out to be a penalty. It has more a punitive character than a penalty which reflects what the actual damage of the other party is. And in civil law, we always have the reasonableness and fairness which can be invoked to deny the reliance on a clause because it is considered to be unreasonable. Attorney fees were mentioned. Entire agreement you should be aware of by now. Under common law, any reliance on what is discussed, communicated prior to the contract or after the contract is excluded by an entire agreement clause. All that is arranged and constitutes obligations between the parties is in the contract, and nothing outside of the contract can change that. Only the parties themselves can, of course, change the contract. A change of control clause may be used to avoid that when you deliver to a company and that company is taken over by your competitor, that you have to continue delivering to what is now a competitor. So with a change of control clause, you can stop that. Then we have just discussed the 11 Incoterms, and you should be able to understand what the consequences of each term are. And we have discussed third party risk in the context of chapter 6. Companies increasingly want to defend their reputation by including so-called corporate social responsibility and anti-corruption clauses in their contracts. So by doing so, by using this party autonomy opportunity, they can impose ethical legal behavior upon their customers and suppliers. And in order to reinforce that obligation on customers or suppliers, they may include in the contract a clause which allows them to audit that other party. In other words, to check the books and to check the commercial business practices of the other party in order to assess whether indeed that other party complied with the anti-corruption and CSR clauses in the contract. Now, if we look into the study which is referred to here, we can create a list of most negotiated contract terms. Now, some of them are not a surprise, they're pretty obvious, like what the goal of the contract is, what the obligations of the parties are. In commercial contracts, of course, the price to be paid, delivery clauses, but this one is maybe not so completely obvious as the previous one. Service level. Many a product comes with service, maintenance, repair. So in contracts you will find clauses which try to define and try to imagine how complicated that can be. The service levels to be provided by the seller. Performance clauses to make sure that in the contract you have defined what you can expect from a product which you buy. Here we have one which we saw in the previous list, an exemption clause to limit liability. Payment clauses, will come to the payment methods in a few slides from now. And then this one is also important. We have not yet touched upon privacy, but privacy, security and cybersecurity are increasingly becoming concerns for company. And needless to say, party autonomy allows you to use the contracts to make clauses which ensure that your partners comply to data protection rules or take measures to make sure that not via their systems information about you can be hacked or otherwise retrieved and come in the open and maybe be damaging to your business or your reputation. And change management then refers to the MAC clause we just discussed, the material adverse change clause, which allows you to stop delivering when a company you supply to is taken over by a competitor. Now, we mentioned the payment risk in international business. And here we have a so-called payment risk diagram, which is based on the two parties in an international sale of goods contract, the exporter and the importer. 4 payment methods are mentioned: open account, waiting for the payment; documentary collection, which refers to a bill of exchange or draft; a written document which matures on a certain date in the future, and on that date the payment is made; and we see letter of credit, and we see cash in advance. Now, it will be perfectly clear that when a cash payment or an advance payment is made prior to delivering the goods, and in the context of international business, prior to shipping the goods, that for an exporter is a fantastic position. Money in before you deliver the goods, that's an ideal position. But you can imagine that for both parties, risk is involved with respect to the payment, and that they would like to mitigate that risk. Now, that can be mitigated by an instrument, which is a contract, and that contract is referred to as letter of credit. Here we have a part of such a contract, and in that contract we see an importer who is in Romania, who buys goods from an exporter, a company which is in Seoul, Korea. Both of them have a bank, and these banks play a crucial role in this letter of credit contract. This letter of credit contract, and we go to the bottom, is based on documents. When the seller can show to his bank a document evidencing that he shipped the goods, the seller gets the money from his bank. How does that work? Well, that works as follows. The procedure is here simplified. We have an exporter and an importer who enter into a sales contract. The exporter and the importer agreed on a letter of contract. The role of the importer, point 2, is to go to his bank and apply for a letter of credit. The letter of credit must be issued by the bank of the importer to the bank, which we call the advising bank of the exporter. If that is the case, the advising bank, the bank of the exporter, confirms this to the exporter. At that moment, the exporter knows that when I present a document that evidences my shipment of the goods to the importer to my bank, I get my money. That is indeed true. The advising bank of the exporter gets the document evidencing shipment. He immediately pays that bank the exporter. Following, the advising bank goes to the issuing bank, number 7, with the documents, and the issuing bank then pays to the advising bank. This provides certainty to both importer and exporter. Exporter has a certainty that when shipping he gets his money, and importer gets the certainty that the goods are shipped to him. That's the letter of credit in a rather simplified way presentation. Now, another element of international goods transactions is the transportation. We have already seen that the transportation can be managed by the seller or by the buyer, and who manages which part of the transportation results from an Incoterm. Now, the party which is responsible for transportation involves a transportation company, and that contractual relationship is called a carriage contract. Now, carriage contracts, irrespective of the modality, because we can have it by road, we can have it by sea, we can have it by air, and we can have it by rail. Irrespective of that, carriage contracts have very specific principles, and we list here 3 of them. The carrier is under the obligation to deliver the goods in time and without damage. That means if he doesn't, it is a breach of contract, non-performance, and the other party can invoke remedies. However, generally, and this is of course at the prejudice of the other party, the liability of the carrier is maximized. So there's a limit to it. And there's another limit to it, and that is that parties which want to make a claim on a carrier based on the contract they have with them must submit that claim for damages or invoke the claim by litigation in a court case. It must be done within a certain time limit. If the time limit passes, the contracting party that contract the carrier cannot invoke those claims anymore, cannot start a court case anymore. So that are the principles. Now we will look into one international convention, the Convention on Transport by Road, which is referred to as the CMR. And that CMR applies to all contracts over road where the two parties are in different countries. This convention imposes on the carrier to issue a so-called consignment note, and the consignment note is an evidence for the other party that he has contracted and made goods available to the carrier. The principle is very strict liability for the carrier. Article 17, the carrier is liable for total or partial loss of the goods and damage thereto between the time when he takes over the goods and the time of delivery, as well as for delay in the delivery. If, however, the carrier, under circumstances, and that's the next slide, invokes that he is not liable, that is not always possible. In the case of willful misconduct by the carrier, and that misconduct can of course be done by a driver of the truck, then the carrier may, under these circumstances, not be able to invoke the clauses of the CMR which protect him. You should realize that the CMR and general transport conditions of the transport industry, and the Netherlands that is the VENEX, they impose a limit on the liability. And that limit to the liability is linked to the IMF's special drawing rights. Now, to keep the story very simple, it comes down to a limit of around €10 per kilo of the transport. So in practice that means that goods which are light but very expensive, like medicine, are confronted with this €10 max per kilo. So if that is the case and you transport light but expensive products, you better take an additional insurance because the liability of your carrier is rather limited. So beware of that. Now, ladies and gentlemen, we've reached the point of integration. And what it will demonstrate is that something we said in the very beginning, that international business contracts are interesting for lawyers, that is demonstrated in the next slide, in which we show you a checklist for international business. So here we have it, a checklist for you, manager, and maybe even for some lawyers, of the elements of an international business contract. Now, the situation should now be that you recognize and hopefully understand what is meant with each of these elements. You hopefully also see why international business contracts are interesting for lawyers, because you have to draw together business and law elements, and you have to draw together various what we call under civil law branches of law. For example, you'll find intellectual property reflected in this contract. When we talk about transportation, we have to bring in carriage contracts. What is also interesting is when the contract is under Dutch law and you use common law terminology like the entire agreement clause, what does that mean under civil law? Now, we will not make it too complicated. You hopefully understand what with each and every element is meant, and we finalize the lecture and this integration by getting back to two of the basic elements which were discussed in this class, and you'll find them in the list on the right hand. You'll find choice of law, dispute resolution, and forum. Those are the two big risks, that you end up with a contract on which a law is applicable which is not yours, and that you may have to go to a court in another country. What negative consequences that can have was discussed, and now you may easily say, I work for a Dutch company and we want to have all of our Dutch contracts under Dutch law, and the choice of forum is a choice for a Dutch court. That is easy to say, but you should realize something, and that is that in business life there are differences in power. And you may be small and the other party may be big, and the other party might simply say, if you don't want English law, then we stop the negotiations, because it is a take or leave it situation. If that is the situation, you have no choice, and if you for commercial reasons decide to accept English law, then that is the law which applies to the contract, and then that is the law which a court will apply in case of a dispute. So we have theory, and the theory is it is not nice to have a choice of law for a different legal system, etc. And we have practice in which there are power differences between the parties. Let that be the last remark of this lecture. There's a reality and there is theory, and you have to deal with the theory which we discussed today in your future business reality. Good luck with it. I'm sure you have come to the conclusion that it is pretty complicated. And if you draw that conclusion, that is something I'd like to hear, because something which is complicated is a challenge for you as a future business manager to overcome. Thank you, and hope to see you in the next lecture.